Good morning, good afternoon, good day to everybody. My name is Marcy Koski. Welcome to our webinar, CFPB's Path Forward After the Supreme Court Decision. We're so grateful you're joining us today. I'm a partner in our Consumer Financial Services team leading the group. Our fabulous Consumer Financial Services team is spread out across our footprint and beyond. We have both a strong regulatory team complemented by an amazing litigation team, and be sure to stick around for continued superlatives, use of superlatives. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit them via the question box. We will try to monitor your questions and answer them during the webcast today, but if there's a fuller answer that's needed or we run out of time, we will follow up with you. A PDF of the presentation is available in the Program Materials folder. This program has been approved for legal education hours. For live attendees, report your hours by clicking on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. That's very important to us as we use your feedback to plan future programs that respond to your business needs. All right, that's all for housekeeping needs. Let's get started with our program. Joining me today are my partners, Chris Friedman and Mike Silver. Chris is one of my trusted regulatory partners on our consumer finance team based in Nashville. Chris brings a deep and broad set of experience in the financial services industry and advises all types of consumer lenders on complex regulatory and compliance issues. Mike is also one of my trusted regulatory partners. He joined our team recently after more than a decade at the CFPB, basically starting when the CFPB started or was enacted, or Dodd-Frank was enacted and the CFPB took row, where he played a central role in writing some of the agency's most impactful rules and guidance, including the payday lending rule that we're going to discuss today. And he advises our firm's consumer finance clients on regulatory compliance matters. So with that, I'm going to hand it over to Mike.
Thanks so much, Marcy. I'm really glad to be here to present along with Marcy and Chris. This should be we're hoping it's an engaging discussion about the recent Supreme Court case and all of the many implications for the CFPB's work. So here's a summary of what we're going to cover. We're first going to just talk briefly about what is the CFPB for those of you that may be less familiar with the agency. Then we're going to do a little bit of a summary of the decision itself, as well as the background leading up to it. And then talk about various categories of implications, the implications of the decision for the agency as a whole. And then more specifically, the implications for the agency's policy agenda through rulemaking and guidance and through its enforcement program. And then finally, we're going to talk about what this means for the implementation of the payday lending rule. So the CFPB basics. The CFPB is an independent federal agency that was created in the 2010 Consumer Financial Protection Act, or is more colloquially known as the Dodd-Frank Act. It is an agency that consolidated consumer protection authorities that previously were dispersed across a multitude of federal agencies. And essentially the premise was that after the financial crisis of 2008, policymakers and Congress believed that, sorry for the too fast clicking ahead, that the disbursement of those authorities had a negative effect in terms of regulators not being able to react quickly enough to the events that cascaded and turned into the financial crisis. So the authorities that were previously held by agencies such as the Federal Reserve Board, the OCC, HUD, the FDIC, et cetera, were consolidated into one agency that is focused solely on consumer protection. as opposed to, again, previously, a number of those agencies had dual mandates in the sense that they were both charged with consumer protection as well as safety and soundness. The CFPB has quite broad enforcement and rulemaking authorities over what the Dodd-Frank Act defines broadly as consumer financial products or services. And the CFPB's enforcement and rulemaking can cover both covered persons, effectively entities or individuals who are engaged in the offering or making of those types of products or services, as well as service providers. The CFPB has somewhat more limited supervisory authority, and it depends on the size of the entity as well as the type of the entity. For depository institutions, banks and credit unions, the jurisdiction is triggered if the asset size of the entity is over $10 billion. For non-banks, there are three different ways that the CFPB can exercise supervisory authority. One is that a limited number are specified in the Dodd-Frank Act itself, such as payday lenders. The CFPB also has the ability to issue through a rulemaking to define what are called larger participants in credit markets. And to date, they've either proposed or finalized 6 larger participant rules. And finally, there is a separate authority where the CFPB can exercise authority to designate entities for supervision if they believe that they pose systemic risk to consumers. The CFPB has been more aggressive about using this particular authority under the leadership of Director Rohit Chopra. And finally, I wanted to touch on a prior Supreme Court decision in Celia Law, which was in 2020. And this is also a bit of a setup for the rest of the discussion. When the CFPB was created in the Dodd-Frank Act, there was a lot of debate, and there still is debate, about certain structural components of the agency. And in particular, there were 3 components that critics of the agency have long cited as, in their view, being problematic. One is that, as originally structured, the agency's director was only fireable for cause. The president could not fire the CFPB director simply because of policy reasons or things that are beyond what are case law would define as reasons for cause. And the second piece was the funding mechanism, which we'll talk about later, and was the focal point of the new Supreme Court case. And the third is that there's a single director as opposed to a commission structure. And so in the 2020 Celia Law case, the Supreme Court found that the original enactment of the Dodd-Frank Act, the structure where the president could not fire the CFPB director other than for cause, was unconstitutional, because it did not provide the president with the ability to hold the agency and the CFPB director appropriately accountable to the executive. So right now, the CFPB director is terminable at will. And that change had a predictable outcome in 2021, January, when President Biden took over and the prior CFPB director, Kathy Kraniger, resigned on that day. So with that set up, I will now actually, at the right time, put forward the next slide. So the CFSA v. CFPB, the background and decision. Chris is going to talk in a minute about the decision itself. And this was ultimately a case about constitutionality of the agency and the issue of its funding mechanism, as I just mentioned a minute ago. But how this case started and where it's ending, as we'll talk about later, is over a fight about the payday lending rule from 2017. And I've tried to simplify these procedural steps here. The full story is about as complicated as the novel War and Peace. It's a torturous, convoluted situation, but let me break it down now. So in 2012, and it's personal, as Marcy mentioned, when I was at the agency, I worked on the payday lending rule on the team for 5 years. So the rule started to develop in 2012, very early procedural steps several years before rule drafting. all the way through 2017, when in October, the final rule was issued. So it was a 5-year, essentially, rulemaking process. And the final rule had 2 major components to it. The first, and much more robust and occupied a lot more ink in the Federal Register notice, was a mandatory set of underwriting requirements for payday lenders and vehicle title lenders. The second piece, which was a much more targeted and narrow remedial measure, was a set of limits on payment collection attempts. The CFPB had developed evidence and cited it in the final rule that customers of payday lenders who had provided account access as security for repayment of the loan often did not have enough funds in the account to repay the loan, and lenders were trying to collect the payment, sometimes by breaking up the payment attempt into smaller chunks. Consumers were getting hit with NSF fees and overdrafts. So this second piece of the 2017 rule was a way of trying to alleviate those harms by setting a limit on 2 payment attempts before having to get reauthorization. So shortly after the final rule, and again, remember, the final rule had these two separate but related pieces to it. The final rule was challenged in federal district court in Texas by trade associations for the affected parties. This happened around the same time in late 2017 that the director of the CFPB, Richard Cordray, resigned his post. There was then an acting director, Mick Mulvaney, who was essentially moonlighting at the CFPB while he was the head of the Office of Management and Budget under the Trump administration. Under Mick Mulvaney's acting directorship, the CFPB announced that it was going to reconsider the rulemaking. They had a different policy view as to the direction of the rulemaking. So the litigation was then put on hold because the trade groups and the CFPB agreed to essentially stay the litigation pending the possibility of a new rulemaking. So hopefully you're still following this. The CFPB then stood up a new team. I was not on that team, that essentially unwound the original rule. And that was a 2-year rulemaking process going through notice and comment. At that point, the CFPB now had a Senate confirmed director, Kathy Kraniger. The final decision was made to revoke only the first part of the 2017 rule. So only the underwriting requirements and the UDAP analysis and findings that underlaid that requirement were revoked. The payment provisions, the limits on payment collection attempts, were not touched by the revocation, meaning that it was the decision of first acting director Mulvaney and then director Kraniger to retain that part of the rule. So the CFPB finalized the rule in 2020, and then the litigation sprung back into action in the sense that the trade groups then filed an amended complaint that focused just on their what they perceived as legal deficiencies of the payment attempt provisions. It then went to a summary judgment in district court. District court found for the CFPB on all issues, and these included claims under the Administrative Procedures Act, claims that the CFPB exceeded its statutory authority, and a number of other statutory and constitutional issues, including the one that we're mainly focused on here. And then the Fifth Circuit Court of Appeals in 2022 found that the CFPB did not violate any of the other statutory provisions like the APA. They found essentially that there was a clean administrative record. There was not an excess of the CFPB's UDAP authority. And they found for the CFPB on literally every other issue until the end, where they spent about 5 pages of a 30-page opinion saying that the CFPB had exceeded the Constitution's appropriations clause because effectively there was nothing about the rule or the rulemaking process that was deficient. It was the mere fact that the CFPB was funded through a non-appropriations mechanism that made the rule, and essentially any rule passed by the CFPB, invalid. So there was like the fruit of the poisonous tree in a sense. So the CFPB then petitioned the Supreme Court to hear the case. The Supreme Court agreed, and then there were oral arguments last October. And so now I'll turn it over to Chris to talk about the CFPB, the Supreme Court's decision.
Thank you so much, Mike. Notwithstanding how complex the issues were and how much ink was spilled over this particular case, the ultimate decision was fairly simple and straightforward. And as a surprise, it was issued by Justice Thomas. I think after the oral arguments occurred in that case, I think many people were kind of less surprised in terms of the outcome of the decision because, frankly, the oral argument did not go particularly well for Noel Francisco and the CFSA's counsel. However, it was a surprise that Justice Thomas issued the decision. But again, it was very simple. And I think it comes down to this one quote that Justice Thomas made where he determined that when the Constitution was ratified in the 18th century, and this is a quote, appropriations were understood as a legislative means of authorizing expenditure from a source of public funds for a designated purpose. And when you think about that particular quote, there is effectively a two-prong requirement that came out of that decision. First, if you have to identify the source of the public funds. Second, those public funds have to be authorized to satisfy a specific and designated purpose. And when you look at how Congress funded the CFPB, it was fairly simple to make a determination that regardless of where those funds came from, there was a source of those public funds, and they were designated for a particular purpose. Thomas discusses in the decision how that interpretation was supported by both English and American early history, which kind of comports with this originalist understanding of the Constitution and the Appropriations Clause. Justice Thomas looked at how legislators during the period around when the Constitution was ratified exercised a very wide scope of discretion about how to allocate funds and where those funds came from. And then finally, Justice Thomas took a look at other federal administrative agencies, such as the Customs Service and the Post Office, who were allowed to use funds without really an annual appropriation of collected monies. So that's really the basis of the decision. Now, there were two concurring decisions. One that was drafted by Kagan and joined by Justice Sotomayor, Kavanaugh, and Barrett. And this really takes what Thomas said and broadens it to a certain extent. Justice Kagan says, and this is a quote, that the CFPB's funding scheme, if transplanted back to the late 18th century, would have fit right now. But she emphasizes that the same would be true really at any other time in our nation's history. She talks about a continuing tradition in which Congress creates a variety of mechanisms to pay for government operations. So even though there's not an exact replica of the CFPB throughout U.S. history, she stresses that the essentials are nothing new. And it was devised more than as part of kind of a 2 centuries long unbroken congressional practice that would not have been surprising to the founders. So that kind of takes what Thomas argued, which is very much based in 18th and 19th century governing practice, which again, that's not surprising for Thomas because he wants to situate things back in the 18th and 19th century, and it expands it throughout the entire course of American history. And then there was a second concurring opinion by Justice Ketanji Brown Jackson, and she rules on a much narrower textual grounds that look, the funding scheme meets the minimal requirements, and it's a very textual argument. It just meets the minimal requirements, and that Congress decided that the funding mechanism should arise out of the broader concern that regulated entities might capture the funding process. And the idea is that the CFPB was created as a result of the crisis that was occurring in 2007 and 2008. And Congress, in its wisdom, decided that we should isolate the CFPB's funding from outside political pressure to a certain extent, and that courts should not second guess Congress's response to this national crisis. So 3 different approaches, but one, if you look at the actual concurring opinions, there is a sense that there might be 5 votes that would take this beyond the originalist argument and maybe expand it a little bit. So I thought that was very interesting. Unsurprisingly, we had a dissenting opinion by Justice Alito, joined by Neil Gorsuch, and Alito takes Thomas's kind of approach of this applies kind of a different heuristic to it, right? A different interpretation. That he argues that centuries of historical practice show that the Appropriations Clause demands legislative control over the source and disposition of the money used to finance government operation and projects. Where you really have an argument, and I think this is really interesting, is that you have 2 originalists arguing against each other about what the proper originalist understanding should be, which I personally think is very interesting. I think that stands kind of for this idea that not that there are limits to the originalist understanding, but that history is difficult to interpret, right? You can look at all the original sources and come up with 2 completely different understandings of how you should understand kind of what was happening in the 17th and 18th century. And for lack of a better term, history is really hard to do. And I think this really illustrates that point. So I'm going to send it over to, I believe, Marcy to discuss implications for the. Yes.
Hi, your sound is going a little in and out. Can you hear us okay?
Sorry.
Okay.
Yep.
Yeah, before you go to the poll, what's interesting, and we were chatting about this yesterday, is that, other than the dissent, right, there's nothing in the decision from the majority or otherwise that somehow admonishes the CFPB, right? Like there's no sort of nugget or warning to the CFPB like, hey, you guys got to back off from your aggression, right? It was very narrow. And in part that could have been, right, trying to get a majority opinion. But we thought it was like insightful what's not in it, right? Not just what's in it.
I totally agree with that. And what is interesting is that you only see that admonition in the Thomas Gorsuch dissent, right? And that admonition is built into their argument, which is to say, look, yes, you're right. There are administrative agencies that have this kind of funding structure, but the CFPB is so bad and the CFPB has so many problems and it is so powerful that it should, notwithstanding everything else, be subject to annual scrutiny through the appropriations process. So, and that, again, very interesting to me. That seemed to me that Thomas didn't buy into that argument, which is interesting on its own. So with that, I'm going to go ahead and read this poll question before we send it over to Marcy. Who did you expect to win the Supreme Court case? I think my answer would change based on before and after oral arguments, but I'd love to see what everyone else has to say about who they thought would win. All right, and actually I was wrong. Mike is next. So
all right, I think I'm give everyone okay. Looks like we got 69 for the CFPB, 30% for CFSA. Yeah, and Chris, I totally agree. I think the conventional wisdom completely shifted after the oral argument. In fact, I was at a mortgage bankers conference in early May, a week or two before the decision, and somebody asked the room, please raise your hand if you think the CFPB is going to lose, and not a single person raised their hand. So I think by that point it had been baked in. So I'm going to talk a little bit about kind of what this means, sort of big picture in the gestalt, for the agency. And again, I mean, speaking as somebody who was inside the agency until the end of January, I was experiencing and feeling some of these, feelings about the existentialness, if that's even a word, of the case. And the most obvious implication is that it avoids a result that would have been unbelievably chaotic. I don't know that anybody actually thinks the Supreme Court would have, even if they had sided with CFSA, that they would have allowed, for example, an outcome where rules were declared invalid retroactively. There was a lot of written speculation prior to the oral argument, that the Supreme Court might fashion some sort of prospective-looking remedy that would try to avoid those types of unsettled scenarios. The Mortgage Bankers Association, again, they submitted an amicus brief that I think really compellingly crystallized the issues that type of outcome would have presented. Focusing a lot on, for example, the mortgage rules that were passed by the Bureau between 2012 and 2014. That essentially, if those rules were held to be invalid retroactively, the statutory provisions would have snapped back into effect. And in a lot of cases, the CFPB took positions in the rulemaking and deviated from the statutory mandates using certain exception authorities under TILA and Regulation Z. So things like the qualified mortgage rule, the loan originator compensation rule, there were much more onerous provisions in the Dodd-Frank Act in some cases that the CFPB used their policy judgment to deviate from, and those would have, in theory, retroactively, snap back into effect. So that's just one example of all the potential chaos that would have ensued. So just taking that off the table, again, even if it was really just a theoretical concern, and frankly, the Fifth Circuit, in its opinion, did not grapple with these issues. They framed the remedy as being limited to the payday rule, even though the logic and force of their opinion, I think everybody viewed it as having much broader effect. So just taking that off the table was a huge relief, I think. And secondly, just again speaking for someone who was there until just recently, there's a psychic and morale boost to agents, to leadership, but also to career staff, particularly people that have been there for, as I was, since near the very beginning. Putting this in context, if you look at the types of constitutional challenges to the agency going back 10, 11 years, for example, in the DC Circuit, in a case against the PHH Corporation, which was a RESPA Section 8 case about captive reinsurance agreements, it ended up becoming a constitutional fight. Justice Kavanaugh, who at the time was on the DC Circuit as an appellate judge, wrote an opinion in 2016 that found the CFPB to be unconstitutional based on the single director being not answerable to the president, only being fireable for cause, the issue I mentioned earlier. That litigation and then subsequent other circuit court litigation that made its way to the circuit courts were grappling with the same issues. And in that particular case, the full DC Circuit ended up rehearing the case, found the agency to be constitutional. So they essentially reversed Kavanaugh's 3-judge panel opinion. The RESPA piece of it stayed the same, but the constitutional result reversed. But then 3 years later, again, when the same type of issue in a different case went up to the Supreme Court in Celia Law, Kavanaugh was on the court at that point, and there was a 5-4 majority in favor of the position that he had taken in the DC Circuit. So I raise this as an example because it shows that there have been literally probably the majority of the years of the agency, there has been some major constitutional case that has been pending in the federal circuit courts or in the Supreme Court. And that takes a cumulative toll at some point from a resource perspective, from frankly, a policy perspective in very nuanced ways. So, again, just a small example, when the PHH case was pending in the DC Circuit, because it turned into a constitutional issue and then it ended up, having to be reheard by the full DC Circuit, the CFPB was a bit hamstrung in its ability to move forward on certain things related to rest with Section 8. There were housing counseling agencies that were asking the agency for guidance on how to structure funding arrangements with lenders. And, there was a several-year process when the full type of guidance could not have been given because of the pendency of this litigation and the unresolved nature of it. So this is just something that I think will sort of put wind in the sails, but also kind of just removes that lingering, ever-present situation where there are constitutional challenges being filed in district court and then moving to different appellate courts and different types of constitutional challenges. And the agency, and Chris will talk about this in a minute, the agency can focus, and I think outside stakeholders can also focus on, is the agency exercising its statutory authorities properly? And scrutinizing the legitimacy of the agency's actions as opposed to the legitimacy of the agency itself. And, the agency is taking a victory lap. When I was at the agency in the Office of Regs, we often had a meme when good news would happen. One of us, and usually it was me because I'm a Generation X stereotype, we would circulate the meme of the Breakfast Club where Judd Nelson in the last scene of the movie would walk across the football field and put his fist up, while Simple Minds was playing. And that was absolutely the moment that happened the day the decision dropped. I heard from friends at the agency, there literally was shouting in the halls. And again, well-deserved. It was a huge victory for the agency. And so I think they're right to feel a spring in their step. At the same time, again, focusing on what is the agency actually doing and all of the challenges and concerns, frankly, that a lot of stakeholders have about how they're exercising their authorities. And also looking at whether the agency should be focusing more on internal agency building. And then finally, I think you're probably going to see some more action in Congress. There has been really a perpetuation of attempts to legislate solutions, whether it's a commission structure or change aspects of the CFPB's authorities under abusiveness or the like. I do think now with the potential for existential legal threats to be at least removed for the time being, you're going to see more focus on trying to achieve structural change through Congress. And now I'll turn it over to Chris. Oh, but Marcy wants to weigh in.
Yeah, thanks. Before you move along, I just want to put in a plug for a recent op-ed that Mike had published in the American Banker. It's fascinating from my perspective. I started practicing law when the CFPB opened its doors on the industry side, right? And Mike started his consumer credit practice at the CFPB. So it's really fascinating to hear from Mike, and I hope you all are enjoying as much as I do hearing his insights. This American Banker op-ed really delves into some of the early years, and I think gives some unvarnished truth about how the CFPB has played out back then and how it continues to play out and how there really is a need for the agency to mature. So while, yes, the fist pumping from the agency, no doubt that's happening, hope it takes a real strong good look at, the next years so we are not facing this constant whiplash in the industry.
No, thanks for the plug, Marcy. I mean, as I wrote in the piece, I have my older daughter just turned 12, and she's, she loves Taylor Swift like every other girl her age in America, and she's awesome, but she's not quite mature, and neither is the CFPB. It's like we forget that it's only 12 years old. Like we should give it some grace and space to grow up, but at this point, it needs to grow up. All right, Chris, take it away.
Fantastic. So What are the implications for industry and agency challenges? And I think the first question, and Mike really, I think, hit on this earlier, but are existential type legal challenges to the CFPB dead? And I think the question probably depends on who you talk to. I know certainly that I read a Wall Street Journal op-ed, I don't know if it was last week or the week before, talking about different ways to challenge the CFPB, right? This idea that, well, because the CFPB's funding has to come from the Federal Reserve's earnings, well, that means that because for any year that the Federal Reserve does not turn a profit, there are no earnings, and therefore, anytime the CFPB was funded from those non-existent earnings, anything that the CFPB did during that period is just bad and won't work. I think, again, whether or not that's a colorable argument depends on who you talk to. I don't really have a strong opinion on it because, frankly, I haven't delved into the details of it. But I think there are some people out there who do feel like, hey, we should give this another college try. But I do think that at this point, there's probably some diminishing returns to those efforts. And I think that certainly at this point, I think we can conclude that you can't rely on the courts to bail out the industry from a strong CFPB. In addition to the CFSA case and to a lesser extent, the Celia Law case, which are the two big attempts to really curtail the industry, you have the recent Texas lawsuit filed with regard to the CFPB's credit card late fee rule, right? And it was filed in the Northern District of Texas. Judge Mark Pittman got it. He is a Trump appointee in a traditionally industry-friendly Northern District of Texas. And Judge Pittman has been trying as hard as he possibly can to get that case transferred out of his court to the District of D.C. for months now. And there's this fight between him and the Fifth Circuit about whether or not this can be sent away. And frankly, that has caused a lot of confusion in the industry. I know certainly there have been a lot of articles written about, hey, we just want to get this thing stayed. And instead, we're seeing this fight about whether to transfer the case. And again, that really stands for this idea that courts are unpredictable, and notwithstanding the fact that you have a traditionally friendly Fifth Circuit, we can't depend on that to come and save us. So the courts are not a surefire strategy. So what else can we do as an industry to maybe curtail the CFPB when it starts acting on some of its excesses, right? Well, I think, again, Mike talked about it earlier. There's a lot of juice left with regard to challenges to individual rulemaking and with regard to whether or not those rulemakings comport with the CFPB's level of authority, right? The CFSA case resulted in a lot of stays of a lot of litigation. And in a lot of those pieces of litigation, stays are going to be lifted, and claims that were not related to the appropriations clause are going to be litigated. So there's going to be a lot of new law coming out of this, right? Law related not necessarily to whether or not the CFPB is a constitutional entity, but with regard to what is the scope of the agency's authority. We're seeing that with the late fee rule. We're seeing that with Dodd-Frank 1071. We're seeing that with regard to the UDAP exam manual. I know that Marcy's going to talk a little bit more detail about some of these, but I think what we can do is anticipate a lot more litigation on these more granular issues. And frankly, I think these more helpful issues because, the CFPB is still a young entity. It's a young agency. And I think it's going to behoove the industry to have more law out there that really defines how much power this new agency entity has. So yes, courts are unpredictable. Yes, we cannot depend on them, but we can still file lawsuits. We can still do things like, and I'll talk about this in a second, but draft really good comments that create a great record for litigating some of these industries. So yes, you have the tool of litigation. But what are some other tools? Well, another one is the Congressional Review Act under 5 U.S.C. 1881 through 1888. The CRA is a means by which Congress can directly overturn an agency action. The Congressional Review Act was enacted in 1996 as part of the Small Business Regulatory Enforcement and Fairness Act. And under the act, agencies have to submit a report of all the rules they propagate, not just the CFPB, obviously, because the CFPB wasn't around in 96, but every administrative agency has to submit a report of the rules. And then both houses of Congress can issue what's known as a joint resolution of disapproval. Now, most of the time, these go nowhere, right? Especially when you have a divided Congress like we do now. But if both houses of Congress issue this joint resolution of disapproval, and if it's passed and signed by the president, or if a president, if their veto is overridden, then the rule does not go into effect. Now, we saw this means of challenging agency action really kind of go into overdrive during the Trump administration. I want to say 14 resolutions of disapproval were successful. And then during the Biden administration, 3 of them have been successful, including in 2021, when the CRA was used to overrule the OCC's true lender rule. I think for the agency, unfortunately, that happened. So it doesn't always work in the industry's favor, but it can work. But I think it really depends. It's a very political process, obviously, because it depends on Congress and the president. So unlike litigation, we really have to, it's not a surefire of a way to challenge those agency actions. So that's kind of the second way you can go about maybe using a different tool to leverage political authority. The third way is the comment and rulemaking process, right? Obviously, anytime an agency issues a rule or wants to propose a rule, there is a comment, an open comment process. And obviously it's less effective than the CRA, because if you there's no way to just really kill an agency action using the comment process. But it does give the industry an opportunity to help move things in the right direction. And frankly, and I know that some of my colleagues will say, you're a little too positive about this, Chris, but I have seen many instances where the comment process has worked to move the agency action in the right direction. And frankly, read any rule that comes out, and you will see the CFPB saying, look, we got actually a pretty good comment from this trade group, and we decided to do this instead of this because the this trade group convinced us that we had an issue here. And I think, and Mike, correct me if I'm wrong, because you've been on the other side of the process, you've read comments. I think that when you see a comment that really does identify with a level of specificity, right, there's this issue or this problem, if you identify that with a pretty high level of specificity, I do think that the CFPB is receptive to that. So you identify those key concrete issues that are going to be a problem, and they will listen. And I've had conversations with other folks in the CFPB, and they've said, look, when you actually identify something and don't hit your shoe on the table, you actually might get somewhere. Mike, I'll give you an opportunity to kind of follow up on that.
Yeah, I totally agree, Chris. Like to me, when I was sitting in the seat of often being the first person to review a very substantive long comment letter and try to figure out how to react to it and how to feed that comment into the policy process for final rule. Yeah, I was always, just speaking for myself, I mean, something that, to me, the most important thing was to engage with the proposal on its terms and not to create a straw man and not to just lay out your criticisms, because all that does is preview your litigation strategy. And I think it just makes it easier to dismiss for purposes of the rulemaking itself. In terms of influencing the final rule, engage with the engage with the proposal on its terms, suggest alternatives, give data, give information about operational and implementation pieces. Maybe that's a bit of a blind spot that the CFPB has. And also, frankly, we're seeing this, Marcy, or we'll get to this later, Chris, there's an RFI out there, request for information on mortgage closing costs. Engage as early in the process as you can, early and often, provide that data, feed it into the process, because there's, even under leadership that may, perhaps doesn't seem as receptive to feedback across all quarters, I think the comment process still gives you an opportunity to shape it in some ways.
Great. Thanks, Mike. So the last thing I want to say before we move on, because I know we've got more to talk about, is regulatory implementation. And that's really what happens after the rule is issued. Again, I've had conversations with folks at the CFPB, and once that regulation is issued, the CFPB is receptive to requests for things like FAQs and other types of guidance, again, when you identify that concrete issue. So now we're going to move on to implications of the CFPB's rulemaking and guidance. And Marcy, I'm going to send it over to you to talk about those implications.
Great, thanks, Chris. Good reminder on the notice and comment and making full use of that. Although I will say, what is the saying? Hope springs eternal on that. And just thinking through some of the recent rules that have been finalized, including the non-bank repeat offender registry, which I'll talk about in a little bit. But nevertheless, good point, absolutely. Also made me think that this is truly a full contact sport to be involved in this practice area. So let's talk about some implications on rulemaking and guidance. So most direct implication for rulemaking is the resolution by the Fifth Circuit on 3 major CFPB rule or guidance vehicles. Let me start in the reverse order. So the UDAP examination manual updates regarding discrimination and unfairness. As many of us or all of us recall, in 2022, the CFPB updated its exam manual to dictate that fairness included the concept of discrimination. So in addition to ACOA and Reg B, the CFPB said that discrimination is also unfair. There was no identification of protected classes or any additional information. So the industry was left with a lot to grapple with. Well, a few months thereafter, several trade associations, including the American Bankers Association and the U.S. Chamber of Commerce, sued in Texas, requesting a stay of that UDAP manual as revised. The court agreed and stayed the UDAP manual or the revisions thereto, and then the CFPB undertook its own action, removed it from the UDAP manual. Now, the court granted the stay in part based on the CFSA case being heard by the Supreme Court, but also on the additional basis that the Dodd-Frank Act did not give the CFPB authority to regulate discrimination except under specific circumstances, such as through ACOA, right? And that it makes sense. If unfairness meant discrimination, why would we need to use discrimination or reference discrimination or regulate discrimination specifically if unfairness or discrimination is encapsulated within the meaning of unfairness? The court granted plaintiff's motion both on the CFSA case, but also on the independent grounds that characterizing discrimination as unfair went beyond the CFPB's authority. It invoked the major questions doctrine in doing so, which is an interesting doctrine and has been used in that recent EPA case in the last couple of years that was issued by the Supreme Court. So now, it continues to be stayed. The Fifth Circuit will have to address the issue of whether or not the change to the UDAP manual exceeded the CFPB's statutory authority. In the Section 1071 litigation, so similar circumstances, trades sought an injunction in response to a request from American Bankers, the Texas Bankers Association, and Rio Bank, and implemented a stay of that rule to all lenders last October. That stay was entirely dependent on the CFSA decision. Now, with the reversal of the CFSA decision, the CFPB has come out and issued revised compliance dates. And the first compliance date is as early as October. Now, the litigation continues. The trades filed a motion for summary judgment, and we'll continue to see activity from that litigation. But in the meantime, the rule itself is not stayed. The credit card late fees rule also that is has a lot of twists and turns in that litigation. Mike has been keeping abreast of that more closely than me. And Mike, you want to chime in?
Yeah, no, thanks, Marcy. Chris covered most of this already, but just suffice it to say, it's become essentially a food fight between the Judge Pittman in district court in Texas in the Fort Worth district and the Fifth Circuit. So now it's twice Judge Pittman has attempted to transfer the venue of the case to the DC District Court, and the Fifth Circuit has stepped in to stop that from happening. There's been all sorts of procedural fights over whether to grant a preliminary injunction, whether Judge Pittman was being dilatory in terms of how quickly he was handling the case. The challengers had requested expedited hearing because the CFPB only permitted 60 days for compliance, which is a very, very short time frame. So the status right now, as far as I understand it, is that the Fifth Circuit has weighed in and kept the case in Texas for the time being. But I think the bottom line is that it really reinforces Chris's point, which is that courts can be unpredictable, and the courts in the Fifth Circuit have proven to be a pretty hospitable place for challenges to Biden administration initiatives. And in this case, they drew a bit of a wild card in terms of Judge Pittman seeming to side several times over with the CFPB thus far. So let's talk a little bit just about, we only have a little under 10 minutes left, so we'll try to go through the last few slides relatively quickly. But the implications for the CFPB's rulemaking and guidance agenda, and some of this is really not directly flowing from the results of the case. It's more stuff that's already been on the agenda, on the unified rulemaking agenda. So the CFPB is moving ahead with an ambitious agenda for 2024 and beyond. So there are 5 final rules that are expected, or in some cases have already been partly released this year. And that would be, the first would be the overdraft rule. So this would be a restriction on overdraft fees charged by very large financial institutions, essentially depository institutions over $10 billion in assets. And the issue there is whether overdraft fees are considered finance charges under the Truth in Lending Act. There's been a longstanding exemption that essentially means that they don't have to follow the various requirements, disclosures, and otherwise. So that would change that particular exemption and allow overdraft fees only to a break-even threshold. And they propose things ranging from $3 to, I believe, $12. The NSF fee rulemaking, and I was the lead of that before I left the agency. NSF fees and overdrafts, of course, are often viewed as two sides of a coin. The Bureau, though, took a very different tack in the proposal where they relied not on TILA authority, but on UDAP authority to propose banning certain types of NSF fees that are charged on instantaneous declines of debit card, ATM, and certain peer-to-peer types of transactions. So it's really a very narrow, very targeted approach. These types of transactions don't actually occur in today's market. It's really more of a prophylactic rule trying to get ahead of potential migration of these types of charges becoming prevalent in the future. And there's also some action there in the proposal discussing the Bureau's positions on abusiveness and the payday rules and where it left the Bureau for its abusiveness authority, which is also a significant part of the proposal. And then finally, the Section 1033 personal data rights or open banking rule, that's been something that's been in development for many, many years. The proposal would have required financial institutions to make available certain data to consumers and to authorize third parties that relates to consumer transactions and accounts. And it would establish privacy protections and data access standards. What is interesting is that just recently, just last week, the Bureau issued a final rule that related narrowly to the standard setting issue. So they evidently have made a decision to split the final 1033 rule into two components, and they released the final piece related to standard settings last week. So I'll let Marcy talk about the remainder of the slide.
Thanks, Mike. So continuing its sharp focus on non-bank supervision and enforcement, we have a twin set of proposed rules, one that is still proposed and one that was just finalized last week, that would regulate non-banks and would require certain registration. So the first non-bank registry to discuss is the terms and conditions registry. This is still proposed. Last week, the CFPB announced a circular, or posted a circular about the use of fine print, but did not release the non-bank registry proposed terms and conditions rule. So this terms and conditions rule, there's suspicion out there among us that its purpose is to impact the use of arbitration agreements. So 10 or more years ago, the U.S. Supreme Court largely sanctioned the use of arbitration agreements in consumer agreements. Fast forward to 2017, 2018-ish, when the CFPB issued an arbitration rule that was subsequently CRA'd when Trump took presidency. So as Chris mentioned, CRA, there was a ton of usage by Trump using the CRA authority. And I'll mention that given these releases of finalized rules, that's probably in anticipation of a potential change in administration, trying to get ahead of that 60-day window to utilize the CRA. I'll note that we have 3 minutes left, so I don't want to rush through this, but we're probably going to have to rush through it. So non-bank registry terms and conditions hasn't been finalized yet, but if finalized, would require non-banks, supervised non-banks, to submit certain terms and conditions to a registry with the CFPB. The rule that was finalized last week, the non-bank registry enforcement orders, also characterized by Chopra as the repeat offender registry, requires basically all non-banks, you're subject to the rule unless you're not, requires non-banks to submit certain enforcement orders to the CFPB. One change from the proposed rule to the finalized rule is that there is now an option, or will be an option, for a non-bank to register, do a one-time registration of an order to the NMLS. And that would be in lieu of submitting the information to the CFPB. However, that option is available only if the CFPB is not involved with that covered order. All right, moving along, we talked about the CRA, also the election, right? Like, depending on what happens in fall, this could turn everything on its head. Mike and I have talked at length about how the Celia decision, the consequence of that is that the CFPB may be more subject to political whims, because you'll have a potentially a new president who is able to appoint a director who thinks quite differently from Director Chopra. I'll pass it to you, Chris. Oh, you're on mute.
Thank you. So I don't want to spend a lot of time on kind of what we can look forward to, because, you know, if you're on this webinar, I would assume you've been on webinars that are similar, and there's a lot of resources out there on these issues. But, you know, what we are going to see is the FCRA rulemaking. And I think either today or yesterday, we now, as of today or yesterday, we now know that the medical debt reporting provision is going to be split from the FCRA reporting decision. But if you don't know about the FCRA rulemaking that's coming out, learn about it because it is a really big deal for the entire industry. And any of us on this call or any one of us at Husch Blackwell in our group can talk to you about it. So please feel free to reach out. Similarly, the mortgage closing cost junk fees rule is a big deal for the mortgage industry. We do anticipate a SBREFA proposal. And again, anyone on the Husch Blackwell consumer finance team can talk to you about this provision as well. So I'm going to throw it over to Mike to talk about some of the guidance.
Yeah, just keeping Chris's thread here. The buy now, pay later interpretive rule was a very big deal for folks in the buy now, pay later space. This was a few weeks ago. It was an interpretive rule, not a final notice and comment rulemaking that essentially declared BNPL providers to be card issuers under TILA. So essentially the same status as a credit card issuer, and said that they have to follow the open-end credit provisions in Regulation Z. My colleague Susie Seaman is a true expert on credit card issues, has really been digging into this. She and I wrote a piece together. Without going into a lot of detail, it's a little bit of an interesting tour to try to get from the point of a buy now, pay later, 4 or fewer installment, saying that that's open-end credit, but that it's not a credit card subject to the really onerous provisions of the Card Act. So it's an interesting way that the CFPB got to that place. And then earned wage access. So this is essentially advancing wages for folks that maybe otherwise would be going to a payday lender or a title lender. There's been some debate about whether these types of loans are credit, both at the state level and the federal level. The CFPB issued guidance in 2020 that took the position that at least as to products with certain features that they weren't considered credit. The payday rule in 2017, which we talked about before, carved out wage advance products based on kind of similar reasons, but there's been all sorts of speculation. The CFPB has encouraged it through some of its state level advocacy letters it sent to California, for example, in terms of California's law that they're looking at implementing, to suggest that the CFPB is going to take a different stance or a stronger stance in forthcoming guidance. And then I'll let Marcy speak to the rest of the issues on the slide.
Great. Actually, I'm going to wrap it up since we're a few minutes over. Thank you so much for joining us today. We hope the information was helpful to you, and we really hope that you complete the short survey. Other additional reminders: this has been approved for legal education hours. To report them, click on the CEU icon at the bottom of the screen. We'll also be sending a certificate of attendance, including course numbers, to you tomorrow by email, along with a recording of the webcast. And thanks so much to my fellow colleagues. We look forward to hearing from the audience on our survey. Thank you.